Good morning. This session will be another series of frequently asked questions we receive at Caltha. This morning I'm going to be discussing typical costs associated with dealing with contaminated properties. In order to understand the costs, I'm going to refer to a case study. Looking back at the timeline for this particular case, we go back to the year 2000 when the lender and the current property owner conducted a Phase 1 environmental site assessment for the property, which identified no environmental issues. A few years later, the owner decides to put the property up for sale, and the next year, a prospective buyer and their lender conduct another Phase 1 on the property. This time, potential contamination due to a neighboring property was identified as an issue. A Phase 2 environmental site assessment was conducted, and that confirmed that the site had contamination of soil and groundwater. Just to put this into perspective, we're interested in this building, this site in the center of the photograph. The adjacent building, adjacent property that we're interested in is to the left. The nature of the contamination that was found along the boundary of this property was consistent with the types of materials that the neighbor was using, and the neighbor was located uphill or up gradient of the property that we're interested in. Going back to our timeline, unfortunately, with the information that there was existing contamination on the property, the prospective buyer ended up dropping out of interest in the property. This left the owner of the property with the responsibility to report the information of the contamination to the state duty officer. At that point, the owner and their lender submitted an application to the Minnesota Voluntary Investigation and Cleanup, or VIC program, and MPCA issued a no association letter to both the owner and the lender, which released both from direct liability for any subsequent investigation or possibly cleanup that might be required for the property. So let's put this in perspective of typical liabilities and the costs associated with the elements of that liability. First, a Phase 2 environmental assessment, a Phase 2 investigation is typically going to cost somewhere between $3,000 and $8,000. A application to the VIC program in order to get a release from liability after that Phase 2 is generally going to be $1,000 to $2,000. If an investigation is required for a piece of property, a soil and groundwater investigation is typically going to be in the range of $20,000 to $30,000. It could be more. There would be some legal and engineering costs associated with the investigation, and then the MPCA will be requesting reimbursement for their staff time to review all of the investigation reports. Then there'll be ultimately a risk assessment to determine whether or not there is cleanup that's required or if the contamination can remain in place. So at this point we have gone through an investigation which simply tells us the extent of contamination and whether or not actual cleanup or remediation is required. If remediation is required, this is where costs start to expand quickly. Groundwater remediation is the most costly typically. It ranges typically from $50,000 to well over $250,000. It could be quite a bit more. Soil remediation is generally less expensive. It's going to be generally greater than $5,000, up to $20,000, but again, it could be a lot more. Again, we've got legal and engineering costs, and once again, the agency will be requesting reimbursement for their staff time. So going back to our case study, the first scenario was actually what we went through. So we had a Phase 1, a Phase 2, and the property owner and their lender entered the VIC program and got a release of liability. The cost for that scenario is typically going to be somewhere between $8,000 and $11,000. However, if a phase one had not been completed and there was investigation and potential cleanup required, there are three additional scenarios which might be followed. Um, the first would be if contamination is discovered and is ultimately determined not to require remediation. So in this case, the costs for going through the process would typically be in the range of $30,000 to $50,000. It could be more. This is actually a similar cost to if the contamination is ultimately found to be coming from a neighboring property, and the owner of the neighboring property is made responsible for investigation and, if necessary, cleanup. The last scenario is if the contamination is ultimately found to be coming from uh, previous activities on the property that you occupy. In this case, having to go through the investigation and cleanup process, it's not unusual for the range in cost to be $100,000 to $350,000, and obviously it could be quite a bit more. So there is some residual liability that will be retained even once the contamination issue is resolved with the agency. There can be activity and use limitations put on a property. There could be worker exposure issues that need to be addressed, and quite often that is from a soil vapor intrusion. There could be civil suits which are not directly addressed by agency enforcement action. And then as a rule of thumb, there's generally a 15% property reduction in value just from the stigma of contamination. So hopefully this provides some useful information in understanding the costs associated with addressing contamination on a piece of property or the adjoining property. If you do have any further questions, feel free to contact Caltha LLP. We'll put you in contact with one of our environmental professionals and can answer any questions you have. Have a good day.